Jason Monroe was an equity partner at Braewood&Simmons, a leading corporate law firm in Sydney. Earlier this year, Monroe represented Sea Globe in a civil dispute. The theme park was sued by the Royal Society for the Prevention of Harm to Animals, RSPHA, for the negligent treatment of bottlenose dolphins. The RSPHA claimed that Sea Globe trainers regularly forgot to feed the dolphins. Sea Globe kept a schedule which required their trainers to sign and date when the dolphins were fed. While reviewing documents for the case, a junior lawyer at Braewood&Simmons found several schedules which were not signed or dated by the trainers. Monroe destroyed the schedules so they were not made available to the RSPHA during discovery. Marlee is a junior lawyer at Braewood&Simmons in Sydney. Last year, she graduated from a leading law school in Adelaide with exceptional grades. She was a senior member of the university's Law Society, where she organised numerous rallies for climate change and racial equality. Marlee's role at Braewood&Simmons is to review contracts and assist with discovery. In her first few weeks at the firm, she discovered the schedules for the Sea Globe trial, which revealed that the dolphins weren't regularly fed. When she presented the schedules to Monroe, he said, "Don't worry about this, I will take care of it." Monroe has a reputation of zealously advocating for his client, which is a characteristic highly regarded in the firm's competitive culture. After the case went to trial, Marlee was surprised that the RSPHA didn't rely upon the schedules that she found. She raised this concern with Monroe, who said that she should be careful if she wants to keep her job. He said to Marlee, "It's just some dumb fish anyway, who cares?" Marlee has not seen any of her co-workers speak up against this culture of zealous advocacy. She begins to think that this overly zealous advocacy is not as questionable as she originally thought. Marlee didn't hear anything further about the missing schedules. One of the firm's big clients, Indigo Coal, recently asked Braewood&Simmons to draft a contract for the construction of new oil pipes that will run from Adelaide to Sydney. The firm has been impressed by Marlee's contract review work, and so they have entrusted her with drafting the document. This is the first contract that Marlee has been asked to draft. She feels nervous about her lack of experience. When Monroe gave the file to Marlee, he said, "This is a big opportunity. Don't stuff it up." Upon reviewing Indigo Coal's instructions, Marlee noticed that the pipeline will run through her hometown in Adelaide. The pipeline will cross through the national parkland that Marlee knows is particularly important to the Kaurna Indigenous community. Marlee grew up near the national parkland and has friends in the Kaurna community who regularly use the land. After further research, Marlee realised that a native title claim was made by the Kaurna community, but the claim was rejected late last year. Marlee believes that Indigo Coal's pipeline will undermine her years of work with the Law Society in Adelaide. She wants to raise this with the firm, but she knows that Monroe will dismiss her concerns. The last time that Marlee spoke up, her career at Braewood&Simmons was threatened.
Clearly, Marlee must confront several competing ethical issues. An applied ethical action framework will empower Marlee to dissect the ethical issues at play and hopefully decide the most suitable course of action. We have explored 3 ethical action frameworks in lawyers' ethics and justice: the Breakey model, the Queensland model, and the Parker and Evans model. Our group has decided to implement the Parker and Evans model to address our factual scenario. However, each framework has its own advantages, which we will rely upon throughout our presentation. We will address each element of this model in turn. First, identification of the issues at play, then consideration, and finally, implementation. The identification of actual or potential ethical dimensions should be the first step in any applied framework, as it allows you to brainstorm ideas without the influence of your personal, cultural, or legal presuppositions. Marlee must ensure to identify the key ethical issues early on to avoid her ethical blind spots. This is often a challenging task within the corporate environment. There are many competing stakeholders and interests which can feel impossible to balance. For instance, Marlee must consider whether she should report her superior equity partner, Monroe, to the Office of the Legal Services Commissioner. She must consider her legal and ethical obligations, given her knowledge that Monroe destroyed evidence. She may ultimately feel compelled to become a whistleblower. Second, Marlee must consider whether it is okay to adopt an approach of zealous advocacy for her corporate clients. Monroe evidently fights for his clients without any regard to broader ethical or social ramifications. Moorhead and O'Callaghan have stressed that this mode of zealous advocacy is likely a self-interested and dangerous style of lawyering. Third, Marlee must consider whether it is okay to represent morally questionable corporate clients. Seaglobe attempted to evade their obligation to animal rights, and equally, Indigo Coal appears ruthless against First Nation Australians and climate change action. If Marlee acts for these companies, will she prompt her own demise down a slippery slope of ethically questionable behaviour and decision-making? Marlee must ultimately consider whether she should support her clients to the detriment of the broader community. The pipelines will directly impact climate change and land rights. Ultimately, Marlee must consider her own personal interests. Indigo Coal's pipelines will likely undermine Marlee's personal beliefs and climate change efforts. On the other hand, Marlee may wish to secure her career. After all, she has recently moved cities and requires a job to pay her way. There is clearly a complex range of ethical issues at play. It is important to identify and delineate the most pressing ethical issue that Marlee must examine. Therefore, we have identified one primary question that Marlee must address. What action should Marlee take with respect to her work for Indigo Coal? To answer this question, our group will now turn to the second step of the Parker and Evans framework: consideration.
Marlee needs to consider the standards and values available which will support her in making an informed and reasoned choice between possible courses of action. While the Parker and Evans model provides an overarching framework, it can be extremely overwhelming to understand how to begin a personal assessment of the extensive sources of authority and guidance. Thus, we will also use a list of considerations adapted from the Queensland Law Society's questionnaire for ethical decision-making. Firstly, Marlee should consider the relevant interests affected by the matter. Secondly, she should identify any legal obligations that she must observe according to any applicable rules of professional conduct. Thirdly, she should reflect on the broader ethical considerations that may affect her ethical decision-making and implementation. Fourthly, she should consider other available sources of consultation and guidance. And finally, she should reflect on the consequences of each available course of action. Marlee should firstly turn her mind to the relevant interests affected by the matter at hand. In other words, she should identify the relevant stakeholders. Clearly, Indigo Coal has a vested commercial and legal interest in the outcome of Marlee's decision, in light of her duty to the company as her client. As a client of Braewood&Simmons, Indigo Coal expects that Marlee's contract work will adhere to their instructions, support their commercial interests, and be competently drafted. Secondly, Jason Monroe's remark to Marlee that this was a big opportunity and that she shouldn't stuff it up indicates his interest in the matter. His reputation for zealously advocating for his client suggests that Monroe subscribes to the adversarial advocate model of lawyering, as identified by Parker and Evans. Therefore, Monroe is interested in advancing the interests of Indigo Coal with maximum zeal. Furthermore, the firm as a whole has a vested interest in maintaining a good relationship with Indigo Coal, who is a big client. The firm's competitive culture at Braewood&Simmons also endorses the qualities of adversarial advocacy to an excessive degree. Marlee should also consider third-party interests that may be affected by the matter, particularly the Indigenous community. The native title claim and Marlee's personal relationship with members of the community indicate the community's interest in preserving their connection with the land, which will be adversely affected by Indigo Coal's proposed pipeline. More broadly, Marlee should consider how the general community may be affected. Considering Marlee's history of advocating for social causes at university, it is highly likely that Marlee subscribes to the moral activist model of lawyering. As such, she may consider that it is her ethical duty to provide what Parker and Evans identify as client counseling, by seeking to persuade clients of the moral thing to do, or withdraw if the client wants something else. Alternatively, a responsible lawyering approach may promote paying more attention to the public interest in the administration of justice, through due process and the observation of the rule of law, expressed in Solicitor's Rule 3.1. This form of lawyering may place particular significance on the fact that the native title claim was rejected. Finally, Marlee should acknowledge her own interest in the matter. What is she interested in achieving through her conduct? Marlee clearly wants to maintain her integrity to her personal values and beliefs. However, understandably, she also wants to not only keep her job, but prove her competency as a solicitor. After considering these relevant interests, Marlee should consider her legal obligations and guidance offered by the rules and standards of professional conduct.
Having an awareness that Jason Monroe's conduct in regards to the Sea Globe matter was in clear contravention of several provisions of the legal solicitor's conduct rules can equip Marlee to avoid undertaking an illegal or unethical decision. As such, Marlee must firstly be aware that she has a paramount duty to the administration of justice, as per Section 3.1, and has an obligation to act honestly in all aspects of legal practice, as provided by Section 4.1. As such, in destroying the relevant Sea Globe documents, Jason has contravened this paramount duty, and has certainly engaged in dishonest and disreputable conduct, which is likely to be prejudicial or diminish public confidence in the administration of justice, as per Section 5. Moreover, Jason's conduct is also a clear contravention of his obligation to demonstrate frankness in court, as provided by Section 19, in that he has effectively deceived or knowingly misled the court by suppressing critical material evidence, which would also be illegal in terms of discovery. Marlee may even feel obliged to report this to the officers of the Legal Services Commissioner. Whilst Indigo Coal's instructions to Marlee are not illegal, she perceives them to be unethical in light of her knowledge regarding the spiritual connection that the Kaurna community has to the land, as evidenced by their attempt to claim native title. As such, Marlee is aware that she is obliged by Sections 4.1 and 8.1 to act in accordance with the best interests of her client and follow their lawful instructions, but this may conflict with her personal ethical beliefs. Thus, alongside using the solicitor's rules as a source of authority for understanding the unethical dimensions of Jason's conduct, identifying other enablers, such as the moral-based ones proposed by Breakey, can allow Marlee to direct her decision-making and give voice to her ethical values. Firstly, Marlee needs to be morally sensitive to her ethical dilemmas, which involves acknowledging that there is no simple or clear-cut solution. As such, Marlee's actions should be underscored by moral motives, whereby she prioritizes ethical demands over other interests and pressures as much as possible. In doing so, she can draw on the values and belief structures that she has developed as a student activist. Understandably, she probably feels comparatively diminished in her newfound professional context, but drawing on the moral character that she has cultivated as a student can enable her capacity to be courageous about the Indigo Coal situation. While she is also probably feeling disillusioned by the realities of the profession, it is essential that she recalls the problem-solving, communication, and leadership skills that she has developed. Further, as proposed by Hyams, Campbell, and Evans, having a well-defined and structured plan for managing her ethical problems can enable Marlee to feel prepared and confident about the approach that she takes.
While considering the factors that contribute to ethical decision-making, it is also important to account for circumstances that may cause Marlee to deviate from her ethical standards. As seen in the Sea Globe matter, Marlee's conduct of advocating her ethical concerns regarding the schedules being destroyed has attracted threats from Monroe, who has acted as a blocker to her ethical decision-making. Further, considering Monroe's threats to Marlee in the past and that her previous concerns were not followed up by the firm, both her career prospects and workplace relationships may be at risk should she choose to again raise her concerns. Moreover, the illusion of transparency may have led Marlee to believe that her co-workers' silence to the zealous advocacy of Monroe means that they endorse and support such behavior, which may lead her to follow a similar path. Her concerns regarding the pipelines also lack legislative support, as native titles of the parkland concerned have previously been rejected. Another factor which may prevent Marlee from expressing her ethical concerns is that in raising these issues, she may be viewed as prioritizing her personal interest over that of the client, causing damage to both the relationship with the firm and with her clients. Furthermore, Monroe's unethical conduct in the Sea Globe matter may cause her to act unethically in future matters. As suggested by Robin Holt and Sternlight, observing unethical actions of peers increases the likelihood that the observer will also pursue similarly unethical actions. With a changed ethical stance, it will lead her down a slippery slope. As a result, Marlee may refrain from upholding her ethical standards in the future if her personal interest is again affected. In considering these disablers, Marlee must strike a balance between moral activism and ethics of care to ensure that she does not prioritize any party's interests illegitimately and continue to uphold her own ethical standards irrespective of external factors. In response to her ethical concerns, Marlee can either raise her concern or remain silent. Should Marlee choose to raise her concern, the obvious resolution will be to report the incident to an authority, such as the Office of the Legal Services Commissioner. However, doing so will inevitably mean that some of the confidential information must be disclosed to support the claim, and such act itself contravenes the legal profession uniform law. Consequently, Marlee can face convictions of misconduct as per Section 9.1 of LPUL. However, Section 9.2.3 expressly permits such disclosure for the purpose of obtaining advice in connection with the solicitor's legal or ethical obligations. Given that Marlee is a junior lawyer with no prior experience in drafting, it is imperative that she consults other senior practitioners at the firm who does not have a conflict of interest, or counsellors and the ethics unit of the New South Wales Law Society. Doing so will allow Marlee to avoid potential misconduct and disciplinary actions against her, and at the same time preserving her relationship with Monroe and her client. Ultimately, it is in both the firm's and the client's interest to address Marlee's concerns to avoid potential legal proceedings regarding this issue, as well as protecting the land of Corner community. While Marlee may choose to stay silent on this issue, doing so can potentially cause harm to the land of the Corner community where Marlee grew up, and conflict with the ethical standards of the legal practitioners and that expected by the client of a leading corporate law firm. Consequently, the client faces the risk of litigation, which delays the construction of the pipelines and damages the reputation of the company. In addition, the client may switch to other law firms following such incident and bring an action against the firm for professional negligence.
In light of the overwhelming significance of the disablers that she faces, it is likely that had Marlee not engaged with any ethics in action frameworks, like that of the Parker and Evans model, that she would have opted to do nothing. The effect of Marlee's interactions with her co-workers, like Monroe's attempts to discourage Marlee from being a whistleblower, or her interpretation of her co-workers' silence to excessive adversarial advocacy as endorsing such behaviour, cannot be underestimated. This is because those that have engaged in unethical conduct in the past are more susceptible to doing so in the future, as the path to unethical conduct often runs along a slippery slope. However, having engaged with an ethics in action framework, Marlee can learn from her past actions and become aware of the ethical issues that have arisen. This can enable her to make a decision that supports the ethical beliefs she has. As such, it is likely that Marlee would decide to speak to one of her superiors at the firm, aside from Monroe, about her reservations with regards to drafting a contract for Indigo Coal for the oil pipeline. Once this decision is made, it must be implemented. In doing so, Marlee should reflect on the Giving Voice to Values framework by creating a script to plan ahead for her meeting, which will help her to find her voice if her concerns are not initially received well. In this script, Marlee should address her concerns about the culture of zealous advocacy at the firm, whilst engaging in whistleblowing by flagging Monroe's unethical and illegal behaviour in the C Globe and RSPHA dispute. She should also raise her strong ethical beliefs that she inherited as a result of her work at the university, including her apprehension about pursuing a task which she knows will negatively impact an Indigenous Australian community. After implementation, to supplement the Parker and Evans model, Marlee should review the successes and limitations of the steps that she took in her ethical decision-making by engaging in moral reflectiveness, as supported by Breakey. This will help prevent moral amnesia by ensuring Marlee learns from this experience.